1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honor.
Council, before we have Mr. Chairman call the case, just mention to y'all, one, if we should have any technology problems, everybody just take a deep breath and we'll resolve them. The second thing is that Judge Frierson and I both see physicians that are from time to time, physicians that are in Summit Medical Group. We don't see any doctors here involved in this, and as I understand it, Summit Medical Group is quite large. But we wanted to tell both of you so that if either one of you has a problem with either one of us or both of us sitting on this case, just tell us now and we'll move it along to someone else.
No objection.
Mr. Pryor?
Yeah, no objection.
All right, that's fine. Call the case, please, Mr. Hibner.
Brett Hanson et al. Versus Sarah J. Levan et al.
We'll hear from the appellant.
May it please the court. Good morning, your honors. I'm Hanson Tipton from the Knoxville Bar. Our brief and the trial court's order contain the timeline of events in this case, but I want to point out a few of the important dates in the sequence. On November 30th of 2016, the original complaint was filed with an attached certificate of good faith supporting a cause of action against all defendants, including Dr. Adolph. These were the original defendants. Roughly a month later, these defendants, or the instant appellants, filed their answer, which included a paragraph raising the doctrine of comparative fault against Dr. Adolph. 2 years later, on January 31st of 2019, after a variety of other events, including plaintiff's counsel taking Dr. Adolph's deposition, these defendants moved to amend their answer to add more specific allegations of fault against Dr. Adolph, allegations that were virtually identical to what the plaintiff had alleged in the original complaint. This motion to amend was set by the court to be heard on February 22nd of 2019. Had it been heard as scheduled, we wouldn't be here today. On February 16th, plaintiff's counsel requested to delay the hearing, and defendant's counsel agreed to do so. The hearing was rescheduled for March 29th. On March 21st, plaintiff filed a motion to amend the complaint with an attached amended complaint. Attached to this amended complaint was the same certificate of good faith that had been attached to the original complaint, which had supported a cause of action against Dr. Adolph and included his name on the certificate. On the morning of March 25th, plaintiff's counsel again requested to delay the hearing on the defendant's motion to amend the answer, and defense counsel again agreed to do so, but asked, "Do you oppose our motion to amend the answer?" Plaintiff's counsel did not indicate he opposed the motion, but informed defense counsel that he had filed a motion to amend as well, but defense counsel had not received it yet. Now, your honors, it's important to note here that all of what I just mentioned happened while Dr. Adolph was still a party to the case, having been named in the original complaint. Now, the afternoon of March 25th, after those emails were exchanged between counsel, an order was entered by the court dismissing Dr. Adolph. On June 24th, an order amending the complaint was entered, and the amended complaint was accepted and filed with the original certificate of good faith from November of 2016 attached. This certificate contained Dr. Adolph's name as one of the listed defendants and supported a cause of action against him. On July 11th of 2019, these defendants filed their answer to the amended complaint, including the same specific fault allegations against Dr. Adolph that were raised in their motion to amend the answer in January of 2019 while he was still a party. The parties continued to prepare for trial, which was now scheduled to begin in March of 2020, and these defendants served Rule 26 expert disclosures upon plaintiff in December of 2019, which included disclosure of an expert and opinions regarding the fault of Dr. Adolph causing the injuries alleged. 2 months after receiving our expert disclosures and the month before trial was scheduled, plaintiff filed the instant motion to strike. Now, there are some things in that timeline that we want to highlight. These defendants have alleged comparative fault against Dr. Adolph since our first responsive pleading in January of 2017. We moved to amend our answer to make more specific allegations of fault against him while he was still a named defendant in this action. We are not suggesting that plaintiff's counsel intentionally delayed the hearing on our motion to amend to produce this result. However, regardless of the intent, The delay of that hearing severely and unjustly prejudices these defendants if this court upholds the trial court's order. The first reason this court should reverse the trial court is that these defendants were not required to file an additional certificate of good faith for Dr. Adolph.
Why not?
This is because at all times in this litigation, up to and including today, plaintiff has had in hand a certificate of good faith supporting a cause of action against Dr. Adolph. Plaintiff filed that certificate of good faith with the court not once but twice, including in support of the amended complaint, which we answered with our answer to the amended complaint.
Mr. Tipton, let me ask you the question here. If the plaintiff filed the amended complaint, plaintiff had not attached the certificate of good faith to the amended complaint, what does case law say? What's the case law say about whether or not that complaint would be subject to being dismissed?
We could move to dismiss, Your Honor. I would expect the trial court to grant an extension since there was already a certificate of good faith filed in support of the original complaint with identical allegations.
But what does the case law say that if the plaintiff files an amended complaint and doesn't attach a certificate of service of good faith to it? I mean, isn't there case law on that?
There is case law, and it is subject to dismissal, Your Honor.
Okay.
Now, as I said before,
some of us have been frustrated with that, but
that's correct, Your Honor. But again, that's for a non-party, and our argument today is that as an original defendant to the suit, Dr. Adolph is not a non-party, but we'll discuss that later. As I said before, these defendants have maintained comparative fault allegations against Dr. Adolph since our first responsive pleading. And we also disclosed expert opinions against Dr. Adolph in December of 2019, approximately 2 months before plaintiff moved to strike those allegations on the eve of trial. Now, Your Honor, the purpose of the certificate of good faith statute, as stated by this court and others, is to ensure that claims have merit to prevent frivolous lawsuits. This is true whether it's the plaintiff originally filing the suit or a defendant alleging comparative fault. What's more, the certificate of good faith requirement is not intended to carry a party through all the way to the jury. It is a gatekeeper to allow suit to be brought in the first place. Plaintiffs aren't required to use their certificate expert at trial and aren't even required to disclose who it was. And the purpose of requiring defendants to file a certificate when they allege fault against new non-parties is to give the plaintiff a basis to name those non-parties in the suit. Those purposes have obviously been met in this case. Plaintiff already has a certificate against Dr. Adolph and attached it to the amended complaint. And plaintiff has already sued Dr. Adolph, ruling that these defendants must also file an additional certificate of good faith against Dr. Adolph serves no logical purpose and cannot possibly have been intended by the General Assembly in enacting 122B. Now, this court has examined the certificate requirement in Serbaugh versus Vanderbilt and made a distinction between original defendants and new defendants. That court reached its decision based on the fact that no certificate had ever been filed regarding the new defendants. Under the Serbaugh court's analysis, Dr. Adolph is not a new defendant in this case, and a certificate has already been filed against him twice, attached to the original complaint and to the amended complaint, both of which these defendants answered an alleged comparative fault against him. The distinction between non-parties and new defendants for the purposes of the statute is further illustrated by the fact that defendants are not required to file a certificate to support allegations of comparative fault against named co-defendants. Whereas in this case, there is already a certificate of good faith against a provider, the statute doesn't require an additional certificate for anyone else to allege fault. So we have to ask, Your Honors, if the plaintiff's certificate was sufficient to support a cause of action against Dr. Adolph in the original complaint, how could that exact same certificate with Dr. Adolph's name on it not support a cause of action against Dr. Adolph when it was attached to the amended complaint? If plaintiff knew he had a good faith basis to institute a suit against Dr. Adolph and then sued Dr. Adolph, how can he then claim that defendants are required to produce proof of a good faith basis to allege comparative fault against Dr. Adolph? And how can he use his own delays on the hearing of our motion to amend to produce a situation where he can later strike the allegations made in that motion to amend? Allowing that would be absurd and illogical.
I'm sorry, Ms. Tipton, before you get too far afield on that, go back and explain to me how, though, what distinguishes this from those cases that say Plaintiff, you had a certificate of faith attached to your original complaint. You filed an amended complaint and maybe let one of the doctors out, but you didn't file a certificate of good faith, even though you could have filed the exact same certificate of good faith. You didn't. And so your case is dismissed. How is this different? Distinguish it for me.
This is different, Your Honor, because the plaintiff attached the same certificate of good faith with Dr. Adolph's name on it to the amended complaint. There is a certificate of good faith that has been filed twice with the court, with the original complaint and the amended complaint, that supports a cause of action against Dr. Adolph. Those cases, those other cases involve situations where there was not a certificate of good faith. That's not the case here. Now, our second reason to reverse the trial court, which is an alternative reason, is that if this court determines that a certificate was required, then the trial court should have granted these defendants an extension of time to file the certificate under these circumstances for good cause shown. That good cause being, as previously stated, plaintiff's delays of the hearing on our motion to amend would severely prejudice these defendants. Another reason for good cause is these defendants operated at all times under the assumption that the certificate already filed twice by plaintiff was sufficient to support claims against Dr. Adolph by any party. Only by virtue of plaintiff's delays of the hearing was a situation created where Dr. Adolph was no longer a named defendant at the time that these defendants filed their answer to the amended complaint. Plaintiff not only had his own certificate in hand when he filed his motion to strike, but he also had the opinions of our expert witness that we had disclosed 2 months before the motion to strike.
Excuse me, counsel, for interrupting. As I understand, the trial court made a determination that the defendants did not assert or articulate any specific reasons for good cause. Is that correct?
We did not in the pleadings, Your Honor. We stated at the hearing that we had good cause. And the main reason, which is the most important reason, was that this is a case of first impression, that there are no cases on point regarding a defendant that has been dismissed and then an amended complaint filed with a certificate of good faith against that defendant attached to it. Your Honors, additionally, as a practical matter, trying this case without being able to tell the jury what happened with Dr. Adolph would be absurd, as shown by the excerpt of his deposition in our brief. This case would not be determined on its merits, but rather on a technicality. And finally, the plaintiff has fully discovered Dr. Adolph and deposed him, and also has the opinions of our expert witness against him. Allowing these defendants the requested extension to file the certificate of good faith would not prejudice plaintiff in any way or delay this litigation. So in conclusion, Your Honors, allowing the plaintiff to capitalize on his own delays of hearing our motion to amend and severely prejudicing these defendants by foreclosing their ability to assert comparative fault at trial against an originally named defendant, a defendant they have maintained fault allegations against since day one, would be manifestly unjust, would not be logical, and cannot possibly have been the intent of the legislature in enacting 122. For these reasons, we ask the court to reverse the decision of the trial court and hold, one, that no certificate of good faith was required with our answer to the amended complaint, or in the alternative, two, that we should be given an extension of time to file the required certificate if this court decides it is necessary. Thank you, Your Honor.
Thank you, counsel. We're here from the appellee. You need to unmute.
Thank you. May it please the court, I'm Robbie Pryor of Knoxville. I represent the plaintiffs and the appellees in this case. And I won't bore the court with a recitation of section 122. I think the court is well aware of the history of 122 and 121. It has been the source of many hours of lack of sleep for plaintiffs' attorneys like me since it was enacted. It's been nothing but a landmine for plaintiffs. And there have been many dismissals for lack of a certificate of good faith along the way. To address the arguments of the defendant in this case, counsel makes a lot of excuses as to why he didn't file a certificate of good faith. And I would suggest to the court that, well, he suggests that there was a long consideration and they decided they didn't need a certificate of good faith. And I think I can point out some things that happened in this case that would suggest otherwise. And I'll start with the fact that he not only alleged comparative fault against Dr. Adolph and UHS, but he alleged comparative fault against an RN, Melissa Childress, who also happened to be the deceased mother in this case. And he didn't file a certificate of good faith with regard to her either. And she was a new party. Now, the act makes no distinction between a new party and an old party. It says that if you allege comparative fault against a non-party, you must file a certificate of good faith. We know from Myers that language is mandatory. The issue of delay is an interesting one. Although it seems that through this case and these post trial arguments or post motion arguments, there seems to be some suggestion that that counsel for the plaintiff submitted some delay or encouraged some delay in order to somehow trick the defendant, which couldn't be further from the truth.
I don't think Mr. Tipton is arguing that.
Okay, well, I was offering, because I knew I was going to file an amended complaint. This came after the mediation of this case, these amendments. And it was offered so that he would have to answer the amended complaint anyway, and why go to court twice? That was the only reason or motivation behind that. Now, the issue of my certificate of good faith, an issue that he didn't argue in the court below was that because my certificate of good faith was the same one I filed with my original complaint, that he can somehow rely on my certificate of good faith. Well, when Dr. Adolph is no longer a party, the allegations of comparative fault put the burden on him to provide expert testimony that Dr. Adolph is guilty of some negligence. It shifts the burden. And that's why he must file a certificate of good faith.
Counsel, let me interrupt you here.
Yes.
The defendant had filed his expert interrogatory information before the amended complaint. Is that correct?
No.
He filed
his expert disclosures after the amended complaint.
After the amended complaint. Okay, I misunderstood.
In fact, that's when I began exploring whether he had to file a certificate of good faith. To be honest with you, Your Honor, I didn't know he had to file a certificate of good faith until we got to his expert disclosures. And I was somewhat surprised to find that he didn't list an expert against Ms. Childress, who he alleged comparative fault against. And he was going to offer testimony against Dr. Adolph, which also came as a surprise to me because he had not filed a certificate of good faith. And that is why I filed my motion relative to the comparative fault allegations being stricken. The argument that he maintained allegations of fault that throughout against Dr. Adolph. Every one of these defendants in these medical malpractice cases use the same language relative to comparative fault. He did not name Dr. Adolph, didn't mention UHS or Melissa Childress. There were no specific allegations given, and it only said that there would be actions by others may have been a cause. But then, in answer to my amended complaint, he comes forth with a description, a clear description of what he's alleging against Dr. Adolph, what he did and didn't do, and clear allegations against Nurse Childress. And none of them were supported with a certificate of good faith. It's easy enough for a lawyer like me to come up and say, what's good for the goose is good for the gander. This act, which has had a terrible effect on a lot of litigants, is, in my opinion, it causes more litigation than it should. And, I feel for the defendant in this case, but what he's lost is his ability to allege comparative fault. My case gets dismissed if I don't adhere to this statute. So he's in a much better position than I would be.
The point you're making, I assume, Mr. Pryor, is that he can still assert all defenses that favor his client. He just can't blame the Dr. Adolph.
Absolutely. There's not a default judgment issued against him. He can still defend his client like he's been doing from day one. And, you know, he suggested that, well, Dr. Adolph's deposition had been taken and that somehow supports his argument. But there's no experts were identified or deposed at that point. So, you know, this is a situation where the statute has very clear language. It's not ambiguous, and I don't think he suggests it's ambiguous. So I think the court has to look at the language on its face, and what it says is that it's subject to having the allegation stricken unless I consent. And he didn't ask for consent, and I never gave it. And in that case, it has to be, the trial court has to be upheld. Now, one thing that he talked about is the Serbal case. That case does not stand for the proposition that it only applies to new defendants. That was a case that involved a new defendant. And that was again, this is where the plaintiff got himself in trouble because he didn't file a certificate of good faith when he did waive the defendant's need to file a certificate of good faith. The defendant in that case wanted to allege comparative fault, asked for consent, and the plaintiff gave it. And then the plaintiff amended his complaint and didn't attach a certificate of good service. And counsel did what counsel would have done in this case for the defense. They filed a motion to dismiss relative to those defendants. And if I had not attached, in this court, the court, and Justice Sweeney had it right, and he asked the most important question. If I had not filed a certificate of good faith with my complaint or my amended complaint, what would be the result? I would have had a motion to dismiss immediately. And that's, you know, talking about the delay and how it hurt him. You know, this statute from the very beginning, the notice provisions. What is the practical effect of the notice provisions? Notice is given, and it's supposed to be so that if it's a meritorious case, settlement can be discussed. What has it turned out to be? It's a waiting period to wait and see if the plaintiff is going to step on a landmine, or if they've maybe got an address wrong or not crossed a T or dotted an I. And that in those cases, the defense counsel sits back and waits. They don't call the plaintiff and try to work it out. They wait to see if what? They're going to attach a certificate of good faith. Are they going to adhere to the statute in 122? And if they don't, we're going to file a motion to dismiss. All I've done, the plaintiff's done in this case, is exercise the right under the statute and follow the statute to the letter. And the trial court got it right. As for good cause, in his brief, counsel discusses reasonable confusion as to the law, as always believing that filing was a certificate of good faith was unnecessary. How can anyone read this statute word for word and believe they don't have to file a certificate of good faith as defense counsel? It's written out in clear language. And in this case, we have not only one defendant they're alleging comparative fault against, we get two defendants. We get the mother of this deceased girl, and I can't even tell you what that did in my camp when Ms. Childress, as a nurse and the mother of this child, had comparative fault allegations alleged against her. And so immediately you look for what basis do they have? Surely they discussed this with an attorney, with a doctor or a nurse, and are going to show us, as required by the statute, that they have a good faith basis for making those allegations. So either they were making legitimate, serious allegations of fault against Ms. Childress as a registered nurse, or they were somehow just throwing it out there, making a cruel, unsupported claim meant to harass or intimidate her. I mean, those are the only two options. So they didn't file a certificate of good faith relative to her or to Dr. Adolph, and that's an old and new defendant. And that tells us that they didn't consider filing a certificate of good faith, because I don't think that Mr. Tipton would file that claim without talking to a registered nurse or talking to a doctor, even maybe his client. I don't know, but he readily admitted at the hearing of this motion that he did not have a certificate of good faith and dismissed his claims of comparative fault against her. And it's no different for Dr. Adolph because there is no certificate of good faith. And I will rest on that, members of the court, and ask that the court uphold the reasoned decision by Judge Stevens at the court below. Thank you.
Thank you. We'll hear from the appellant in rebuttal, please.
Thank you, Your Honor. Mr. Pryor says that he seems to make the argument that we didn't really allege comparative fault in our original answer against Dr. Adolph. He said that it was the same language that all defendants use in all cases. Well, Your Honor, we've had cases where that exact same paragraph has been held to have alleged comparative fault, and we got hung up by having those allegations stricken because we didn't attach a certificate of good faith to our original answer. And we had that happen in a case that we appealed to the Court of Appeals, and the Court of Appeals refused to hear it. And so those were allegations of fault against the co-defendant. Plaintiff's counsel discussed the Melissa Childress situation quite a bit. That issue is irrelevant and is not on appeal here. He said there's no difference between her and Dr. Adolph. That's absolutely not true. Dr. Adolph was a named defendant, and there was already a certificate of good faith filed twice in this case against Dr. Adolph. Plaintiff's counsel even said he didn't even know we had to file a certificate of good faith with our amended answer. He said it wasn't until he got the disclosure of our expert that he thought, wait a minute, maybe they were supposed to have a certificate of good faith. And so the law is not settled and the statute is not clear. It says non-party, but the statute doesn't define non-party. What we're saying here today is when a defendant has been sued and later dismissed, and yet the same certificate of good faith is attached to amended complaint, that he is not simply a non-party under 122. The statute, he mentioned, I'm sorry, Your Honor, he mentioned the Serbaugh case and how it does not stand for the proposition of new parties. The Serbaugh opinion uses the phrase new non-parties. It does make a distinction and says that since there was no certificate of good faith filed against these new non-parties, that it should be dismissed. That's not the case here, Your Honors. There is a certificate of good faith that was filed twice in this case against Dr. Adolph. We made specific allegations of fault against Dr. Adolph in our motion to amend before Dr. Adolph was dismissed from this case. Plaintiff knew exactly what we were alleging against Dr. Adolph, and it was exactly what plaintiff had alleged in the original complaint against Dr. Adolph. That's why we were under the impression we didn't need a certificate of good faith against Dr. Adolph, because we had made specific allegations of fault against him before he was dismissed. If the hearing on our motion to amend our answer had not been delayed by plaintiff's counsel, Dr. Adolph would have not been dismissed until after we had filed our answer to the amended complaint or made those specific allegations in our answer. And that's why, Your Honors, a certificate of good faith against Dr. Adolph was not required by us, as he had already been sued and there was already a certificate of good faith against him that was attached to the amended complaint we were answering.
All right. Of course, thanks to both parties, both for your briefs and your oral arguments. Mr. Hibner, if you'll please recess the court until our next case.
This honorable court is now in recess until 10:30 a.m.